The National Council of Provinces is set to debate on the Copyright Amendment Bill this week. It's already passed through the National Assembly. Also to be discussed is the Performance Protection Amendment Bill, both bills seeking to protect the rights of creators and copyright owners. But the Publishers Association has raised concerns that it will be doing the opposite of that. The association says there's need for wider public consultation. To discuss this in more detail, we're joined in studio by actor and chairperson of the SA Guild of Actors, Jack Devnarain, Clint Brink, and patent attorney Andre Myberg, who was part of a panel of legal experts advising the National Assembly on the Copyright Amendment Bill. Gentlemen, good morning and thank you so much for your time.
Thank you.
Jack, maybe let's start off with you. Let's step back. What exactly is happening? What are the issues at play here? Because, like I said, this legislation aims to protect actors, but it seems like it's doing the opposite of that.
Well, not from our perspective. Certainly when you look at what the reforms that are being proposed by the bills, it's a massive step forward. You have to remember also we're talking about rights that already exist. And these rights don't necessarily apply to actors. We're talking about reforms that will apply to actors for the very first time. So we are always guarded when it comes to people talking about we are losing our rights are being eroded, whereas as from the actor's perspective, we are saying we are asking for these rights for the very first time. And that's what we are finding in the Copyright Amendment Bill with the introduction of the Beijing Treaty and the rights that then apply to actors through the Beijing Treaty and through the Performance Protection Amendment Bill, which is a reform when the Act first came out in 1967. And we are saying in 1967, TV wasn't even in South Africa then. The Act was never equipped to protect actors. Now we're in the age of the internet and we're talking about the fourth industrial revolution. The Act is even more inadequate. So we have to find a place for reform and, as I said earlier, to give actors rights that they never had previously.
So, Andre, what exactly are these main loopholes that the legislation will end up closing, and what are the loopholes that have perhaps opened up as a result of the inadequacies in the legislation itself?
Nick, in my advice to Parliament, I focused primarily on the Copyright Amendment Bill. So the Copyright Amendment Bill, in our view, has got a number of deficiencies, both insofar as compliance with international treaties are concerned and also on certain constitutional aspects. The Performers Bill doesn't have the same kind of problems, but the Copyright Bill is linked into the Performers Bill by cross-reference, and the producers who engage actors and who engage musicians, they make their money out of the work through copyright as opposed to performers' rights. And as a result of amongst others, a number of copyright exceptions, very broad copyright exceptions being introduced, it is quite likely that the kind of money that producers are expected to get, that they are expected to share with performers and musicians, will not materialize. And so the problem really lies with the Copyright Amendment Bill, which has got some serious fundamental flaws.
Where did they come from, though? I mean, there's just a lack of understanding by our lawmakers, because these changes have been, some may argue, decades in the making.
A good question, which might take quite a long time to answer, but the origin of the latest initiative was the Copyright Review Commission headed by Judge Farlam, whose report was published in 2012. They looked specifically at the music industry and they made a number of recommendations about the music industry, and these were meant to be taken up in legislation. The legislation, when it at last came in 2015 in draft form, dealt not only with musicians but extrapolated those recommendations across all copyright industries. So not only music and sound recordings, but also literary works, artistic works, and audiovisual as well. And the same problems that applied in the music industry did not exist in the other industries, and these changes were made without really much research or impact assessment at all.
In my very layman's reading of the legislation, I mean, in black and white, it would seem as though there's not adequate permission required to reproduce published works, and that's not only the work of authors but also the work of academics as well.
Correct. This comes about as a result of these copyright exceptions, and there's a wide array of them. It starts off with a new provision called a fair use clause, which has its origin in the US but is far, far more expansive than in the US, and to which are attached further general exceptions, specific exceptions for certain purposes, and ends off with a contract override clause that says that if you can use under an exception, you can never waive your rights. So it really places industries that rely on copyright under a tremendous amount of pressure in relation to reuses of their works without permission. And if there's no permission, then the negotiating power to claim remuneration thereby also goes away.
All right, let's leave copyright for a second and talk about the Protection Amendment Bill. Clint, I mean, this is not only about getting paid and getting paid what's fair for the work that's done by actors, but it's also about recognition at the end of the day.
You know what the difficult thing is? Like, I've been seeing a lot of tweets, and since this this mission has kind of like been surfaced and it's coming to the forefront more. The responses and the types of responses by people, firstly, who are spectators of the industry and what we do, and even people who are operating bodies within the entertainment industry, you can see by the different answers and the way that they respond to this, you really get a sense that no one knows what we do, really. They don't understand what it is, what we go and create, where it comes from, what process we need to go through for us to fulfill what we do at the end of the day, what impact and ripple effect it has on the viewer, and exactly what space we occupy within the framework of a TV or film production. And if you understand that you spend more time with your colleagues than you do with your family, that when you come home and after exhausting yourself by putting yourself inside someone else's consciousness to try and reproduce that, there has to be a certain form of debriefing when you're done with that as well. You know, psychologically, we need to understand people, we need to get into their shoes, we need to actually embody these people, to be honest in our interpretation of the story that we tell. And you know, if you take a look at everything that's on our shoulders, the balance is completely out. It's completely out. So I think each and every actor and performer and even entertainer should not take this this mission lightly. It's something that at the end of the day will benefit all of us and our families and our children, you know.
Jack, I mean, there's no contest that there is a great depth of acting talent and artistic talent in South Africa, but do you think that that's commensurate with our lawmakers in Parliament understanding the ins and outs of the industry and are able to actually tailor-make the legislation that protects your rights and also fosters new talent?
I think part of the problem is, as Andre pointed out, perhaps our legislators need to understand the nuances that will apply to the different creative fields. But certainly we have to appreciate that as much as we are a fantastic nurturing environment for creative talent, the statutory environment isn't enabling enough. And I think we have to take a leaf out of the International's book to see what are the rights that those actors have internationally that not just protect their rights, but also enable them to create. Part of that is a collective bargaining environment where creators are able to sit together with producers and broadcasters, and they will then decide on the future and the terms of their relationships. And that's something that by virtue of our status as freelancers, we are denied in this country. In fact, to the extent that we are not protected by the basic conditions of employment or even safety regulations that you would find in any other industry. How do you establish rates, for example? You know, in any other industry, manufacturing and mining, you can sit in your bargaining council and say this is what a person should be earning. And in our creative industry, we don't have that. And we believe that it's an injustice that simply by virtue of a label of whether we are considered a worker or an independent contractor, that we are therefore denied certain fundamental rights.
Where's the shortcomings there? I mean, you say it's a massive step in the right direction, but
Yeah.
what are the fundamentals that you think continue to evade this legislation?
We need to get some indication from our legislators that we are being heard in certain key areas, and that would include, for example, the right for collective bargaining. And we would have a concern, for example, if all the rights for determining standard contracts would be vested in the minister. We want to have some stake in that negotiation process. And I think this part of the area that is still unfolding. For example, regulations and discussing the regulations that come after the Act is a process that must still be engaged with. And we want to be able to introduce what are international best practices and whether they would have a nuanced fit in South Africa and not just be a replication of. In which case we're going to find ourselves in trouble all over again.
Clint, I mean, in many ways you could argue that the South Africa's artists, actors have lucked out when it comes to this legislation, but publishers do stand to lose. I mean, what's your response there?
To be 100% honest with you, I think I'm speaking in the capacity of the creative, you know, of the person who's out there 7 to 7 trying to do his best with the tools that he's been given, his God-given talent to go out there and reproduce for his family. I think if anything has to happen when it comes to matters like this, I would say my colleagues and my gentlemen to my left and my right will be able to answer that question a lot better than I am.
Well then, let's bring you in, Andre. I mean, how can we fix this legislation? Is there space to even do so? Would you expect the President to perhaps send it back to the National Council of Provinces, National Assembly to fix these deficiencies you're talking about?
Well, the National Council of Provinces has that opportunity now. It is serving before them now, and they are taking their decision on the bill on the 20th of March. But of course the term of Parliament is quickly coming to an end.
Is there not the risk being run that it's going to, they're going to try and push this bill through to be able to say that this legislation has been done in this current term?
That is something that has been indicated, that yes, that is the desire to have it done in the current term. Certainly since the 5th of December when it was passed by the National Assembly, things have moved incredibly fast. National Council of Provinces had a public call for comments, and they gave us 8 days, including a weekend, to respond. Now, for some people who work with us all the time, I suppose 8 days is okay, but when you're looking at very large membership industries whose members are all affected by this legislation, 8 days is really not enough. And unfortunately this bill has got a history of very short consultation periods. I'm working on a consultation in New Zealand that has just started, where they're just starting with their process. They've given 4 months for the initial consultation period.
So this is essentially, to my mind, opening this legislation up to a constitutional court challenge if you're talking about the deficiencies remaining in its current form and it being tried to push through before the current term of Parliament ends.
I'm afraid so, yes. It's possible.
Would you support challenges to the current legislation, even though you have argued that the one piece is a massive step in the right direction, Jack?
I think the NCOP has room to assure all the parties that whatever their concerns are, they will be heard in the various submissions. I absolutely believe that the bill should be passed because certainly from the actor's perspective, we are looking at creating protection. We are looking at revising laws that come from a deeply divided past, from an apartheid era economy. And we need to revise that and reform that soon. And we're afraid that going into a dissolved parliament is not going to be offering any more protection for actors, but less.
It doesn't need to be mutually exclusive, though. The rights to those that produce the content, the actors that you're representing, and those that give it a voice, essentially a platform for your creative content to be aired. Surely the rights of those two groups shouldn't be mutually exclusive.
I agree. In fact, we've been saying all along, and certainly in Saga submissions, that Actors need producers, producers need actors, who all need broadcasters. And for decades, actors have been saying, we want to be able to sit together with all parties. But because actors, by virtue of their status, have so little bargaining power, who cares about having actors around the table? This has led to the prejudice that actors have suffered enormously over the years. And finally, when there's the possibility of having a statute that would hopefully include collective bargaining rights and where the playing field can be leveled, then you have suddenly people hitting the brakes and saying, oh no, well, we can't have this now, can we? You know, can we really be sitting and talking to actors? It's incredible to me that suddenly when there's when faced with social justice, people start to backtrack and they no longer want to be part of the process. We are saying, please join us so that we can do this together and stop creating resistance where there shouldn't be.
Clint, I'll let you have the final word there. Why is there such an uneven playing field, in your own words? I mean, like I mentioned, it's a relationship that's symbiotic. You both need each other, those that publish the content that creators like you guys put together. Why is there this uneven terrain?
I would just say that, you know, the way that it was constructed from the beginning, the imbalance was there from the start. It's difficult, you know, working in an environment where I know that what I need to produce, like within my capacity to fulfill what my character needs to do at the end of the day, and not even have a space to go sit down or even meet the entire writing department, where I am the one that has to have a common ground and a common thread. You have different directors that come in with different styles, different people that write different scripts, but you are the constant. You're the same actor. You're the guy that has to go out there and produce, and you know, I'm also the billboard of the show. I've got to integrate after I knock off at 7 in the evening or whatever. I still have to go out there and talk to everyone else, you know, and ensure that their brand is still likable at the end of the day, you know, and it has public interfacing. So for me, to not have actors be a part of the entire creative process is ludicrous.
Certainly space for further collaboration there, as that legislation stands before Parliament, National Council of Provinces to be exact. Thank you for your time, gentlemen, and wish you the very best in trying to sort these problems out before the current term of Parliament ends. Chairperson of the SA Guild of Actors, Jack Devnarain, Clint Brink, and legal expert Andre Meiberg on Morning News Today.